personal, and tribal. We welcome Hon'ble Justice Surya Kant, Judge Supreme Court of India, Executive Chairman, National Legal Services Authority, to this conference. Lordships, your guidance and support has been pivotal in holding this conference. We welcome Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court of India, and look forward to Lordship's insights on this conference. We also welcome Mr. Justice Rajesh Bindal, Judge Supreme Court of India, whose deep insight and views have always been a guiding factor for all of us in our efforts. We also welcome Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India. Lordship has always been a constant source of support and encouragement. We also extend a warm welcome to Honorable Shri Arjun Ram Meghwalji, Honorable Minister of Law and Justice, who has taken time out of his busy schedule to grace this occasion. Your presence today reflects your deep commitment to the cause of justice. We also welcome Honorable Shri Manoj Sinha ji, Lieutenant Governor of J&K, for his support to all our program, which reflects his deep commitment towards the justice delivery system. We also welcome Shri Umar Abdullah ji, Chief Minister, Union Territory of J&K. Your presence here, sir, reinforces the commitment of a government as an important stakeholder in this conference. We also welcome Shri Javed Rana, G, Minister of Tribal Affairs, Union Territory of J&K, Mia Altaf Ahmed ji, and Shri Ghulam Ahmed Khatana, Member Parliament, who have taken time to attend this function. A very warm welcome to Mrs. Savita Suryakanji and Mrs. Ritu Palliji, who have graced this occasion. We also extend a very warm welcome to Chief Justice Devinder Kumar Upadhyay, Chief Justice Sheel Nagu, Chief Justice Gurmeet Singh Sandhawalia, Chief Justice Arun Bansali, Chief Justice J. Narendra, Patron-in-Chief of the legal services authorities of their states and union territories. A very warm welcome to the Executive Chairperson, State Legal Services Authorities, High Court Legal Services Authorities, High Court of Allahabad, Delhi, Punjab, Haryana, Himachal Pradesh, Uttar Pradesh and Uttarakhand. We also extend a very warm welcome to Shri R.K. Goel, Secretary, Department of Justice, Government of India, and also a very, very warm welcome to Lieutenant General Prateek Sharma, who's here on dais, and whose insights and views are very welcome and important for this conference. We also welcome Chief Secretary Shri Atul Dulu, Shri Nalin Prabhat and their team of officers, and also General Prashant Srivastava, Shri Rakesh Kumar, IPS, CRPF, Commodore Prabhat Malik, Brigadier Gurmeet Singh, and Director Raju Sainik Board. A very warm welcome to Chief Justices, former judges, Director and Member Secretary NALSA and their team of officers, District Legal Services Authority, their team of officers, members of District Judiciary, participant members, members of Defence Forces, participating members of the tribal communities, former Chief Justices, former judges of the High Court, ladies and gentlemen. It is both meaningful and symbolic that this conference is being held in Union Territory of Jammu and Kashmir, a region that has long stood as a citadel of national integrity, soaked in the sacrifice of our valiant defense forces, and enriched by the resilient spirit and vibrant cultural heritage of our tribal communities. What better place to hold this conference than this Union Territory? Jammu and Kashmir is a land of Sufis and saints, but also a land of majestic beauty, historical significance, and of strategic importance, which is blessed by nature in abundance and beauty. But this land is also a witness to the valor and sacrifice of our defense personnel, who have, at the cost of their lives, withstood all onslaught to ensure that the ideals enshrined in our Constitution stand strong for all. Many of these belong to the tribal communities. It is therefore only fitting that we choose this sacred soil for this conference on reaffirming our vision of justice for both who defend our borders with their lives and those who defend their culture with resilience and struggle. This conference seeks to build mechanisms that are culturally sensitive, linguistically accessible, and grounded on the realities of tribal culture. The quest for social tranquility lies in equitable administration of justice, which is imperative for holistic growth and development of any democratic nation. The Constitution of India is the bedrock of our legal and moral fabric, It enshrines the ideals of equality, liberty, fraternity. Its vision of justice transcends barriers, uplifting those on the margins and protecting rights and enabling dignity for all. The judiciary has the sacred role of interpreting and enforcing this constitutional mandate, especially for those who have been historically left behind. Our focus today lies on two sections, our defense personnel and our tribal communities, both custodians of India's pride and spirit. Our defense personnel are the guardians of peace and sovereignty. Their unwavering commitment and sacrifice is the cornerstone of our national stability. Yet, their unique service conditions require us to adopt a vigilant and responsive legal approach. Justice for them must be prompt, sensitive, and mindful of their realities, especially for our ex-servicemen and Veer Naris, who often face a silent struggle when their duty is over or upon losing their loved one. Their reintegration into the society with dignity and opportunity deserve our utmost attention. Equally important is the focus on India's tribal communities, who for generations have battled the scar of exclusion and marginalization. Despite the constitutional protection and reformative approach, deep-rooted inequalities, economic deprivation, and limited access to justice continue to impede their progress. This conference seeks to delve into these challenges and evaluate the effectiveness of current policies while identifying the road ahead for true inclusion. There also exists an intersection between these two communities, as many of our brave defense personnel hailed from tribal backgrounds. They carry their ancestral pride and cultural richness even as they protect the borders. Their challenge is unique, both in the formal system and in the traditional structure. Their journey is shaped by dual challenges of service and social exclusion and calls for an empathetic understanding and focused support from the legislature, judiciary, and executive. To reaffirm the constitutional vision of justice, we require a vigilant judiciary as the guardian of spirit, of rights, and a proactive and responsive executive, ensuring that the policies reach the last mile, an effective grievance redressal mechanism that do not fail the most vulnerable, but most of all, an informed and emphatic civil society serving as a strong bridge between the state and the citizen. This conference aims to focus on the understanding legal perspectives regarding armed forces and the tribal communities, their unique challenges and systematic barriers in legal system, their empowerment, and also to look towards the way forward. Today, we also honor the sacrifice of our armed forces as we observe the 26th Kargil Vijay Divas, and we salute and honor their sacrifice. I am reminded of a famous poem of poet Makhanlal Chaturvedi, which I would like to recite in the honor of Kargil Vijay Divas. चाह नहीं मैं सुरबाला के गहनों में गूंथा जाऊं, चाह नहीं प्रेमी माला बंध प्यारी को लिलचाऊं, चाह नहीं सम्राटों के शव पे हे हरि डाला जाऊं, चाह नहीं देवों के सिर पर भाग्य पर इठलाऊं, मुझे तोड़ लेना वन माली, उस पथ पर देना तुम फेंक, मातृभूमि पर शीश चढ़ाने जिस पथ जाए वीर अनेक. Here in this land that embodies the spirit of sacrifice, the richness of diverse traditions, let us resolve to uphold our collective national commitment to ensure that everyone, regardless of uniform or tribe, is empowered to live with dignity, to preserve their heritage, and to rightfully claim their place. With these thoughts, I once again extend a warm welcome to all and look forward to meaningful deliberation, actionable insights, and strengthened collaborations that emerge from this platform. I welcome the members of the Armed Forces, the BSF, CRPF, Navy, and Air Force. Thank you very much. Jai Hind.
Thank you, Ladyship, for the gracious welcome address. Your eloquent words have set the tone for this event and also reaffirm the values that inspire our collective journey.
Distinguished guests, the defense personnel stand as unshakable sentinels of our sovereignty and to articulate the vision of justice and to lay the foundation for the path of transformative reforms for this constituent. I take the honor of inviting the guiding force and the visionary mind behind this conference, Honorable Mr. Justice Arun Palli, Chief Justice, High Court of J&K and Ladakh, and Patron-in-Chief, J&K and Ladakh Legal Services Authorities, for Lordship's keynote address on the defense segment.
Hon'ble Justice Surya Kant, Judge, Supreme Court of India, and Executive Chairman, National Legal Services Authorities. Honorable Judges of the Supreme Court, Shri Arjun Ram Meghwal, Minister of State Law and Justice, Lieutenant Governor, Union Territory of Kashmir, Shri Manoj Sinha, Mr. Umar Abdullah, Chief Minister, Union Territory of Jammu and Kashmir, Lieutenant General Prateek Sharma, Army Commander, Northern Command, Chief Justice and Judges of the High Court of Delhi, Allahabad, Punjab and Haryana, Uttarakhand and Himachal Pradesh, my sister and brother judges of the High Court of Jammu and Kashmir and Ladakh, Minister for Jal Shakti and Environment and Tribal Affairs Department, Members of Parliament joining us, former Chief Justices and Justices of this court, respected soldiers and fellow citizens. It's an absolute honor and a privilege to stand before the guardians of our nation, our brave men and women who've taken oath not just to serve, but to sacrifice. Good morning to you all. It was 1632 when an English poet, Francis Cowell, said, God and soldier all men adore, in time of danger and not before. When the danger is past and all things righted, God is forgotten and the soldier slighted. But this is India, and in India's heart, the soldiers righted, never forgotten, never slighted. It might come as a surprise to many of us that the laws governing our armed forces, be that Army, Air Force or Navy, include a statutory mandate that whenever a serving soldier is on an official leave, to appear in a civil or a revenue court, the court is bound to prioritize hearing of his matter. The statutory obligation is clearly laid down in Section 32 of both Army as also the Air Force Act and Section 24 of the Navy Act. These provisions contain vital yet chronically underutilized legal safeguards. They postulate that upon submission of a certificate issued by the military authorities confirming that the soldier is on an official leave or has applied for leave specifically to appear in a court, the court is bound to prioritize the hearing and decide the matter within the duration of the sanctioned leave. And if for any reason, or despite best efforts and the endeavors made by the court, is not in a position to dispose of the matter finally, it is required to record reasons and make that reasoning accessible to the soldier, an essential procedural safeguard that upholds both transparency as also the value of the soldier's time. This statutory prescription is not a matter of discretion. It's not an act of courtesy either. That's the law to ensure that the soldier is not weighed down by the burden of pending litigation. The whole idea is to support, to prioritize so that the legal worries don't accompany him to the front lines. This was the true sense and the very purpose, objective, and the idea of these legislations. But yet, over time, this legal protection has slipped quietly into obscurity. It finds no reflection in causeless. It doesn't feature in routine court practices. And in many instances, even the judicial officers remain unaware of its existence. The law offers priority, but process at times delivers delay. It was in this background we were compelled to consider a pressing question as to what exactly have we done to give effect to this mandate. The realization was not rhetorical. It stirred a movement of self-introspection and I'm glad to share with you all, we've taken the first step. But before I touch upon the small little initiatives that we've taken in the recent past, I'm equally conscious and realize that it's just not possible, it's just not feasible for us to embark on this journey alone. Therefore, we earnestly look forward to a meaningful exchange of ideas and constructive engagement, including the insights, experiences, and valuable guidance of our other high courts and state legal service authorities. Your shared perspective will undoubtedly enrich and strengthen the collective pursuit. Adverting to the measures we've recently undertaken, I may share upon realizing that Zilla Signing Boards possess extensive litigation-related data of ex-servicemen. Accordingly, we coordinated with them, mined the data from court information system, tapped every available source of information. Thousands of SMSs were sent to the litigants and lawyers. A dedicated Google form is launched on the High Court website, and voluntarily, submissions are being invited for identification. Thus far, approximately 600 cases have been identified in the High Court as well as the District Court, and it's a work in progress. Prioritization was the next step that naturally followed, and then the IT committee of the court, headed by Brother Shukla, rose to the occasion to leverage the power of technology and developed a dedicated software patch that now enables automatic flagging of cases involving serving personnel and ex-servicemen. Additionally, a real-time urgent matter indicator is also being introduced directly into the cause list, both at the High Court as also the district judiciary, marking such cases for priority attention from the outset. As a part of the institutional commitment to ensure timely and seamless access to justice, the High Court has developed an in-house web application, DPCMS, the Defense Personnel Case Management System. The web application, which will be formally launched in some time from now, is a comprehensive, user-focused tool designed specifically for the legal needs of serving and retired defense personnel. Through DPCMS, users will be able to register their cases, monitor updates in real time, apply for legal aid, submit hearing requests, including for video conferencing, and resolve queries directly from the phones. But alongside technological innovation, there existed a pressing need for structural judicial reform, and I take pride in sharing with you all, my parent court, the High Court of the Punjab and Haryana, long demonstrated an institutional foresight in this regard, as Volume 1, Chapter 6, Part A, B, and C of the High Court Rules and Orders, detailed procedure is laid down for suits by or against the members of the armed forces, including provisions under the Indian Soldiers Litigation Act 1925. And notably, now this is something really interesting, notably Part B outlines the procedure to be followed under the SAT Act, expressly mandating the trial courts to adhere to its provision in letter and spirit. Inspired by this model, and in keeping with the commitment to meaningful reform, the High Court of Jammu and Kashmir and Ladakh introduced comprehensive amendments to the civil rules of practice for the guidance of the district judiciary, mandating that cases involving serving and retired defense personnel receive focused and expedited attention at the district level. Yes, one thing led to another. I'm equally glad to share with you that recognizing the need for institutional synergy, High Court proposed an amendment to Rule 13 of the Jammu and Kashmir Legal Service Authorities rules, framed under Section 28 of the Legal Service Authorities Act 87. For inclusion of Secretary Zilla Sainik Board as a statutory member of DALSA. The proposed amendment was thus a step aimed at institutionalizing coordination between legal service authorities and the ex-servicemen community, thereby enhancing access to justice for veterans and their families. The proposal was formally submitted to the government of Jammu and Kashmir, and I express my deep gratitude to worthy Lieutenant Governor Shri Sinha for ensuring the prompt clearance of the proposal. In fact, the notification has been issued yesterday evening itself. As a result, Rule 13 now stands amended, formally integrating Secretary Zilla Sainik Board into the District Services Legal Authorities framework. We feel privileged to inform this august gathering that we are joined today by our Veer Naris and ex-servicemen whose presence here is both humbling and profoundly inspiring. As part of the pioneering initiative to promote grassroots legal support, Veer Naris and ex-servicemen have been engaged as paralegal volunteers. To begin with, 15 Veer Naris and 8 servicemen, ex-servicemen, have been engaged across UT of J&K and Ladakh, and certificates of engagements will be presented during the course of this event. This initiative creates a trusted interface between legal institutions and defense community, ensuring that legal aid is delivered with dignity and lived understanding. Now, as I move further from here, I also wish to draw your attention to the Indian Soldiers Litigation Act 1925, a century-old legislation, but to date as we speak, profoundly relevant. Now, I would delve a little deep here. There's something really crucial coming your way. Recognizing the unique constraints faced by the soldiers deployed under special or war conditions, this act provides a unique procedural shield. At its core, it provides for the postponement of legal proceedings involving Indian soldiers who are unable to attend court due to service under special conditions. Upon receiving certification from a prescribed authority or the commanding officer, the court is required to postpone suits, application, and appeals until soldiers can reasonably appear. This act also empowers even the collector to intervene in cases where a soldier is unrepresented and appears to be unable to attend court, ensuring that soldiers' rights are not prejudiced due to absence. In such cases, notice must be issued to the prescribed authority, and the court is bound to suspend the proceedings unless exceptions apply. In addition to, now that's another facet to it, in addition to these protective measures, the Act mandates relaxation of limitation periods, excluding from computation the time during which a soldier was serving under qualifying conditions. This applies not only to the soldier, but also to their legal representatives in case of a death during service. In a sense, the Act creates a protective legal framework that shields serving soldiers from procedural disadvantages arising from their service obligations, thereby ensuring that justice is not denied simply because their duty to the nation always comes first. However, if this framework is examined in today's context, a compelling question that arises, which would seek an answer from each one of you sitting here: why should this protection be limited only to the civil and revenue matters? In a time where criminal litigation, particularly cases under Section 138 of the Negotiable Instrument Act, increasingly involves serving soldiers as complainants and becomes imperative to ask, is it not time to extend similar protections on the criminal side as well? And a survey across Jammu, Kashmir and Ladakh revealed that a considerable number of such cases are currently pending before various courts, often involving soldiers unable to meet procedural deadlines due to operational exigencies. The strict timelines imposed for the issuance of a notice or filing a complaint in such cases often exclude those who serve not by law but by circumstances. Soldiers posted at borders in counter-insurgency operations or on prolonged deployments cannot always issue legal notice or appear before the court with rigid statutory windows. And I say this as Patron-in-Chief of the Legal Service Authorities of J&K and Ladakh, that the legislative gap prompted a deeper legal policy reflection. And after extensive research, analysis and institutional consultation, a clear realization emerged that a set of coordinated legislation amendments is necessary to bring the Indian Soldiers Litigation Act 1925 with the demands of modern-day litigation involving defense personnel. And the centenary of this legislation offers a timely opportunity to extend its protective mechanisms to criminal cases where a soldier is a complainant, especially matters under 138 of the Negotiable Instrument Act, and potentially more. This reform effort also aligns with the broader, now this is again crucial, this reform effort also aligns with the broader national imperative, as the Ministry of Defense has declared current year as the year of reforms. So why should legal reform be left behind? Suffice it to say, a comprehensive legislative framework has been formulated, is formulated to the National Legal Service Authorities, and if it finds approval of Honorable Executive Chairman Nalsa, widely known for his unwavering commitment to the institutional excellence, there is every confidence that the proposal will be steered in the right direction. Now, this brings us to something extremely crucial in context of the two central themes of the conference. One that cuts to the very core of the constitutional vision of equal access to justice and which needs immediate gap bridging. Despite forming a deserving and vulnerable class, members of the armed forces, ex-servicemen, and their dependents are not expressly included within the scope of the statutory framework governing legal aid, even though they face a growing volume of civil, revenue, and service-related litigation. There are compelling and multi-dimensional reasons to provide such institutional support. Soldiers often operate under extraordinary constraints, including long deployments, all of which limit their ability to access timely legal assistance. These operational challenges are further compounded by their personal and family vulnerabilities. These difficulties become particularly acute in rural and semi-urban areas where access to legal resources, awareness of rights, and availability of affordable legal advice remain significantly limited. It may again come as a surprise to many that a national level recommendation in this regard existed for over 5 decades. In 1973, much before even the Legal Services Authorities Act even came into being, expert committee on legal aid chaired by Justice V.R. Krishna Iyer recommended that legal aid should be extended to serving defense personnel, ex-servicemen, their wives, and war widows. The committee rightly recognized that those stationed in perilous terrains and remote borders face unique barriers in accessing justice. It aptly affirmed the legal aid in its truest sense must defend the defenders. You serve at the front lines, on mountains, in deserts, across oceans, and yet sometimes your struggles, your voices remain unheard beyond the battlefield. That must change. And I'm quite hopeful, rather a feeling crimson, that possibly that change is about to unfold in a moment from now. Encouragingly, Honorable the Executive Chairman Nalsa, Justice Surya Kant, is here, given the deep sentiment and unwavering regard he holds for the defense forces of our nation. We are confident he has something truly meaningful up his sleeve, something crafted with thought, compassion, and vision as he prepares to launch the Nalsa Veer Parar Sahayata Yojana 2025. And if our sense proves right, this initiative could well mark a watershed moment in the history of legal aid in India, ushering a new era of inclusivity, recognition, and service for those who have long stood guard for the nation. This vision aligns squarely with the very purpose of our gathering today, to bridge the long-standing institutional and procedural gaps that impede access to justice for defense personnel and their families. Ladies and gentlemen, as I draw to a close, I am reminded of a quote I once read. If you truly wish to do something for a soldier, be an Indian worth fighting for. Jai Hind.
Thank you, Lordship, for the keynote address, which has insightfully laid the path for critical reforms, transformative amendments, and renewed commitments of ensuring access to justice for all. Ladies and gentlemen, Kargil Vijay Divas recalls moments that continue to blaze in the national memory, igniting pride and patriotism in every Indian. We are deeply honored to have with us today Lieutenant General Prateek Sharma, Param Vishesh Seva Medal, Ati Vishesh Seva Medal, and Sena Medal, General Officer Commanding in Chief, Northern Command, who has played key roles in strategic military operations, including Operation Sindoor, and I humbly request him for his special address.
Honorable Justice Shri Surya Kant, Judge of the Honorable Supreme Court, Honorable Minister of State, Law and Justice, Shri Arjun Ram Meghwal, Honorable Lieutenant Governor, Shri Manoj Sinha, Honorable Shri Justice Arun Palli, Chief Justice, High Court of J&K and Ladakh, Honorable Chief Minister Shri Omar Abdullah, Honorable Justice Shri Sanjeev Kumar, Honorable Shrimati Justice Sindhu Sharma, Lieutenant General Prashant Srivastava, GOC 15 Court, Shri Rajesh, who is the ADG of CRPF, respected members of the judiciary, esteemed dignitaries, members of the legal fraternity, fellow officers, ladies, gentlemen, and our brave soldiers. Jai Hind. It is indeed an honor and a privilege to be part of the significant event which marks a milestone in the recognition of importance and requirement to focus on prioritization and expeditious disposal of legal cases involving our serving soldiers, veterans, their families, and Veer Naris. The event coincides with 26th anniversary of Kargil Vijay Divas, which recognizes the conspicuous courage, indomitable bravery, grit, determination, and sacrifice of our soldiers, which forced the withdrawal of Pakistan forces from our sacred soil. As you all are aware, that our soldiers serve in the most demanding and often unforgiving terrains under challenging operational environment with utmost dignity, discipline, and unwavering commitment. Every soldier of Indian Army is deeply committed to its oath to serve the nation with honor and pride. A soldier may not always express, but he too is encumbered with the responsibilities back home. And sometimes his innocence and prolonged absence due to his commitment on the borders are exploited to embroil him into avoidable legal issues. As part of a large family, we in the Army provide him moral and psychological support and also be a facilitator to deal with the problems. But a formalized architecture to address legal issues will be a huge morale booster for the Indian Army. Hence, this onerous initiative by the Honorable Judiciary, which focuses on this often neglected need of the armed forces personnel, is deeply reassuring and reinforces our trust and faith in our legal system. This initiative is not just a procedural reform, but has the potential to transform the welfare spectrum of military personnel, especially related to litigation issues, which would contribute immensely to health of our organization. By recognizing the unique nature of military service and creating mechanism for a faster route to justice, the judiciary is paving the way for a more responsive legal defensible system. It will provide a platform for the uniformed personnel, veterans, and Veer Naris to seek timely redressal without hesitation or prolonged distress. The impact of the scheme will thereby contribute to the morale of our men and women in uniform. I urge the esteemed members of the judiciary that this mechanism may be developed in a manner to provide accessibility to each and every soldier deployed in the remote areas along the borders. We assure you of all our support for this unique endeavor. On behalf of the Indian Army and the entire Armed Forces fraternity, both serving and retired, I extend my heartfelt gratitude to the judiciary, particularly to the Honorable Chief Justice of the High Court of J&K and Ladakh, and all those who have worked behind the scene and recognized the unique circumstances and rolled out this landmark initiative. On this particular occasion of Kargil Vijay Divas, I also take the opportunity to pay homage to the brave hearts who sacrificed their lives to protect the sovereignty and territorial integrity of our motherland. Thank you so much, and Jai Hind.
Thank you, sir. In this solemn and stirring moment, when the spirit of service and justice fills this auditorium, it is with great respect and humility that we invoke the wisdom of the Honorable Judges of the Supreme Court of India and Honorable Chief Justices of the participating High Courts, whose gracious presence amongst us today is not only